Good morning, Deputy Chief Justice.
Good morning.
My name is Mrs. Mabasa, appearing on behalf of the applicants in both the matter of Deputy Director of Public Prosecutions versus Cholota and Deputy Director of Public Prosecutions Johannesburg versus Jonathan Schulz. Thank you.
Thank you, Ms. Mabasa.
Good morning, Deputy Chief Justice Mlambo. I am Aina Deson from the Johannesburg Bar, and I confirm my appearance on behalf of the first respondent, Jonathan Schulz.
I didn't get your surname.
Nadesan,
Nadesan.
Nadasen.
Thank you very much,
Thank
Ms. Nadesan.
Thank you.
Good morning, Deputy Chief Justice.
Morning.
I'm Loiso Makapela. I confirm my appearance on behalf of Ms. Cholota, the respondent in the second matter.
Thank you very much, Ms. Macapello. The Constitutional Court today hands down judgment in two applications that were heard together. The first application, CCT 280/24, is the Schulz matter. The applicants in Schulz seek condonation and leave to appeal against the judgment of the Supreme Court of Appeal. The second application, CCT 190/25, is the Cholota matter. The applicant in Cholota seeks direct leave to appeal against the judgment of the High Court of South Africa, Free State Division, Bloemfontein. In the Schulz matter, the first respondent, Mr. Jonathan Schulz, approached the High Court of South Africa, Gauteng Division, Pretoria, in 2022, after obtaining information that the National Prosecuting Authority, the NPA, intended to seek his extradition from the US. He sought, amongst others, a declarator that only the Minister of Justice, in his capacity as a member of the National Executive, has the power to make extradition requests to foreign states. The Pretoria High Court dismissed Mr. Schulz's application. On appeal, the Supreme Court of Appeal reversed the High Court's order and declared that the Minister of Justice, not the NPA, has the authority to request Mr. Schulz's extradition from the US. In this court, the applicants in Schulz seek an order limiting the retrospectivity of the order of the Supreme Court of Appeal and condonation for the late filing of the application for leave to appeal. The Supreme Court of Appeal's judgment in the Schulz matter became pivotal to the Cholota matter. Ms. Nomalanga Moroadi Cholota was extradited from the US in 2024 following an extradition request made by the Director of Public Prosecutions, the DPP. During a criminal trial in the Bloemfontein High Court, Ms. Cholota raised 4 grounds in a special plea challenging the High Court's jurisdiction over her on the basis that her extradition was unlawful. A trial within a trial ensued. During her closing address, Ms. Cholota's counsel produced a copy of the Supreme Court of Appeal's judgment in Schulz and argued that Ms. Cholota's extradition was made by the incorrect state functionary. The Bloemfontein High Court found that it was bound by that judgment and that as a result, it did not have criminal jurisdiction over Ms. Cholota. In a unanimous judgment penned by Theron J., the Constitutional Court finds that the Cholota matter engages its constitutional and general jurisdiction as the matter raises both key constitutional issues and arguable points of law of general public importance. This court also finds that direct leave to appeal should be granted, as it would be in the interest of justice to finalize this matter on an urgent basis. On the merits of the Cholota matter, The Constitutional Court holds that the state's right to be heard was infringed during the trial within the trial, in that counsel for Ms. Cholota raised the argument that Ms. Cholota's extradition was unlawful because it was issued by the NPA for the first time during her closing address. Advancing a new ground for a special plea during the closing address deprived the state of the opportunity to respond in violation of Section 106, subsection 3 of the Criminal Procedure Act. The Bloemfontein High Court erred in dismissing the state's objection on this issue. The second issue this court considers is which state functionary possesses the authority to make outgoing extradition requests. In this inquiry, this court affirms that the legal process of outgoing extradition requests, by its nature, functions at the intersection between domestic and international law. Domestically, the prosecuting authority usually initiates a prosecution and prepares the requisite documents for an extradition request. Internationally, the requesting state generally transmits the request to another state. Necessarily, the international stage of this process involves acts of external sovereignty. In assessing the NPA's powers in this process, this court holds that the final authority to make extradition requests to foreign states is not an implied power of prosecutorial authority. This is because the international stage of outgoing extradition requests entails sensitive diplomatic and foreign relations considerations, which fall squarely within the domain of the national executive. In other words, the international stage of outgoing extradition requests cannot be entirely subsumed under prosecutorial proceedings, and the separation of powers principle forbids the NPA from controlling the entire process. While this court recognizes the importance of prosecutorial independence, it finds that prosecutorial independence does not license the NPA to exercise powers beyond its ambit of authority. The NPA possesses broad powers over prosecutorial proceedings, which cover much of the domestic stage of outgoing extraditions. As a domestic state organ, however, it cannot represent South Africa at a state-to-state level. Therefore, although the final authority to make outgoing extradition requests could affect domestic prosecutions, this court finds that the NPA cannot exercise the external sovereignty inherent in such requests. Regarding the national executive's authority, this court finds that as the state organ clothed with the duty to exercise external sovereignty on behalf of the Republic, it is the appropriate functionary to make extradition requests to foreign states. The executive cannot merely participate in the issuance of outgoing extradition by playing an administrative role akin to that of a conduit. It must apply its mind to the extradition request and exercise a concomitant discretion. This court, however, holds that the Supreme Court of Appeal erred by concluding that only the Minister of Justice can make outgoing extradition requests. That power is vested within the national executive broadly. Therefore, this court concludes that in the case of Ms. Cholota, the DPP did not have the power to make a request for her extradition. To the extent that the Bloemfontein High Court found that her extradition was, for this reason, irregular and unlawful, it was correct. This, however, is not the end of the inquiry. This court next considers the status of the U.S. court order. The DPP argues that because Ms. Cholota was extradited pursuant to an unchallenged U.S. court order, South African courts cannot impugn that extradition. This argument is misconceived. Ms. Cholota challenged acts of South African officials in requesting her extradition, not the conduct of U.S. officials. South African courts are empowered to examine the lawfulness of the exercise of public power by South African officials, and the U.S. court order does not preclude such examination. This court must next determine whether, despite the unlawfulness of her extradition, the Bloemfontein High Court nonetheless had jurisdiction of Ms. Cholota. The Bloemfontein High Court's sole basis for declining to exercise criminal jurisdiction was that Ms. Cholota's extradition was requested by the incorrect state functionary. It relied on Ibrahim for the principle that if there were unlawful or improper conduct on the part of the organs or the functionaries of the South African state in foreign territory aimed at securing the presence of an accused in South Africa, the South African courts are precluded from trying anyone for crimes committed within its borders. There can be no doubt that the Ibrahim principle remains an important feature of South African law. The rule of law and the constitutional guarantee of procedural fairness in criminal cases must be jealously guarded. However, following a survey of foreign jurisprudence which considered the Ibrahim judgment, this court finds that while Ibrahim established an important precedent, it does not mean that any irregularity in extradition proceedings, no matter how insignificant, should result in a court declining to exercise its criminal jurisdiction. Such reasoning is not supported by the facts of Ibrahim and would not strike an appropriate balance between the concern for lawful process and the imperative to combat impunity. A court is only divested of its criminal jurisdiction in cases where the exercise thereof would bring the administration of justice into disrepute. In this case, the Bloemfontein High Court failed to recognize that Ms. Cholota's case differed from the facts in Ibrahim in material respects. Importantly, the NPA operated under the bona fide assumption that it had the necessary authority to request extradition. It was only after the delivery of the Supreme Court of Appeal's judgment in Schulz that the NPA had to grapple with the question of whether it had authority to do so. There has been no suggestion that had the executive and the NPA been aware of the correct legal position, Ms. Cholota's extradition would not have been requested correctly. Consequently, the Bloemfontein High Court erred in declining to exercise its jurisdiction over Ms. Cholota on the sole basis that her extradition was requested by the NPA. For this reason, the appeal must succeed. In the Schulz matter, the applicants seek condonation for the late filing of their application for leave to appeal. Condonation is not there for the taking. The applicants filed their application for leave to appeal approximately 3 months after the 15-day deadline period prescribed by the rules of the Constitutional Court had lapsed. A 3-month delay is substantial, and this court has refused condonation for shorter delays in the past. The explanation for the delay proffered by the applicants leaves much to be desired. They blame most of the delay on their misunderstanding that the Department of Justice and Constitutional Development intended to launch an appeal, and on difficulties they had in briefing counsel, given the state attorney's cumbersome briefing policy. Neither of these reasons is satisfactory. A litigant cannot escape the obligation to comply with this court's rules on the mere allegation that it thought another cited party would lodge an appeal. The applicants abandoned their appeal in respect of the merits and instead only seek an order limiting the retrospective effect of the judgment of the Supreme Court of Appeal. The judgment, they argue, will result in catastrophic consequences for the administration of justice, as it potentially provides a basis for persons whose extraditions have previously been requested by the NPA to now challenge and invalidate such extradition requests. This is the ground on which the NPA bases its argument that the importance of the issue warrants granting condonation. On the Ibrahim principle as articulated, a court ought not to decline to exercise its criminal jurisdiction on the sole basis that the accused extradition request was authorized by the NPA and not the executive authority. This principle would hold true for any extradition request already made. Accordingly, even without the relief sought by the applicants to limit the retrospectivity of the Supreme Court of Appeals judgment, the harm they fear to the administration of justice is largely, if not completely, ameliorated. Accordingly, the NPA cannot slip past the requirement of condonation by relying on the importance of the issue. Thus, condonation must be refused, and the application for leave to appeal must fail on that basis. In case CCT 280/24, this case makes the following order. 1, condonation is refused. 2, the applicants are ordered to pay the first respondent's costs, including the costs of 2 counsel. In case CCT 190/25, this court makes the following order. The application for direct appeal is granted. The appeal is partially upheld, and the order of the High Court of South Africa, Free State Division, Bloemfontein, is set aside. 3, it is declared A, the National Prosecuting Authority has the power to prepare, draft, and submit to the National Executive extradition requests for the National Executive to make such requests to a foreign state. B, only the National Executive has the power to make extradition requests to foreign states. C, the respondent's extradition from the United States of America to the Republic of South Africa was unlawful on the basis that the extradition request was authorized by the applicant or an official within the National Prosecuting Authority rather than the National Executive. However, the fact that the extradition was unlawful, as aforesaid, does not of itself deprive the High Court of South Africa, Free State Division, Bloemfontein, of criminal jurisdiction over the respondent. The matter is remitted to the High Court of South Africa, Free State Division, Bloemfontein, to determine the remaining grounds of the respondent's special plea. I hand down the judgment. Court adjourned.